An Education, Health, and Care Plan, EHCP, is a legal document under the Children and Families Act 2014, providing educational, health, and social care support for children with special educational needs, SEN. Local authorities manage EHCPs, deciding eligibility, funding, and implementation. The CND Tribunal only hears EHCP-related disputes. The Equality Act 2010 protects disabled students, regardless of whether they have an EHCP. Key provisions include the duty to make reasonable adjustments, protection from discrimination arising from disability, protection from indirect discrimination, prohibition of discrimination in education, and schools must not discriminate against disabled students. It's important to note that the CEN Tribunal does not have jurisdiction over Equality Act 2010 claims. These must be pursued separately via the county court or first-tier tribunal. The Human Rights Act 1998 applies to all individuals, including children with disabilities. Key articles relevant to education include the right to education, protection from inhuman or degrading treatment, the right to private and family life, and protection from discrimination. EHCPs do not override the Human Rights Act, but many cases require separate judicial review or legal action in higher courts. In the case of London Borough of Bromley v. Sendist, the Court of Appeal ruled that disabled children have rights under the Equality Act 2010, even if they have an EHCP. Schools and local authorities cannot refuse reasonable adjustments just because a child has an EHCP. In R.N. v. Governing Body of a School, the Upper Tribunal ruled that it was unlawful for a school to argue it was not obliged to provide reasonable adjustments because a child had an EHCP. The CND Tribunal has no jurisdiction over Human Rights Act claims, as confirmed in R.H. v. East Sussex County Council, where the High Court stated that discrimination and human rights breaches must be pursued separately through judicial review or civil court. A parliamentary inquiry found systemic failures in the EHCP system, stating that parents are forced to fight for support, children's legal rights are not enforced effectively, and local authorities delay and deny services, creating unnecessary barriers. Ombudsman reports from 2018 to 2023 showed that over 90% of EHCP complaints investigated were upheld, proving that councils routinely failed to meet their legal duties. In conclusion, the Equality Act 2010 and Human Rights Act 1998 still apply to disabled children with or without an EHCP. Many schools and councils misuse EHCPs to avoid their broader legal responsibilities. The CND Tribunal cannot hear cases on disability discrimination or human rights breaches. These must be pursued separately. Parents often face legal battles to enforce both EHCP provisions and wider legal protections. If you are told your child must have an EHCP to access their rights, this is misleading. Schools are already legally required to provide support under the Equality Act 2010.